At this time, I'm going to ask each panelist to kind of give maybe a 30-second to a minute introduction, who you are, and then we're going to come back and you get a chance to talk about what you do. So, starting here, do you need this mic or do that one?
Hi, good morning, everyone. My name's Brandon Nemec. I'm from the Cook County State's Attorney's Office. I'm an assistant state's attorney, and I work in the legislative unit of the state's attorney's office. What we do is we track the pending legislation and bills in the Illinois General Assembly. So I often, unfortunately, have to take trips down to Springfield as a result of that. I'm here to talk today about the Illinois Concealed Carry law, which I unfortunately was assigned to help negotiate and draft last year. And I'd like to just go over some of the ins and outs of the law, some of the things that I think the community needs to be aware of. Thank you.
Good morning. My name is Monica K. Gamble, and I am also with the Cook County State's Attorney's Office. I am another member of the legislative team. Brandon is my partner. Our third partner could not make it today. I often travel to Springfield with him as well, and I'm here to discuss medical marijuana and some of the nuances of the program as it's starting to be implemented. The law is now in effect, and we're in year one of this pilot program.
Good morning. My name is Mark Kammerer. I'm the supervisor of the State's Attorney's Alternative Prosecution and Sentencing Unit. Basically, my unit works with cases that are not disposed of in a traditional way. So we're responsible for all the treatment courts, the drug treatment, mental health court, veterans treatment courts, all those, but specifically today I was asked to speak about our deferred prosecution programs, which are unique in that if people agree to it and comply with the conditions of those programs, their charges are dismissed outright and they're eligible for immediate expungement.
Hi, my name is Karen Sheely. I'm an attorney at the American Civil Liberties Union. We're an organization that works to protect people's constitutional rights. I work on issues of police misconduct and free speech, among other issues as well. All right.
Hello, I'm Larry Merritt. I'm with the Independent Police Review Authority. I'm the Director of Communication, Director of Community Outreach and Engagement. And I'll be talking about who we are, what we do, and the service that we provide to residents in Chicago, and how to go about filing a complaint regarding allegations of misconduct of CPD members.
All right, let's give our panel a hand. You know, must be dedicated people to get up on a Saturday morning and don't get paid, don't get reimbursement for gas to come over here. This is dedication. So we need to pretty much give them a standing ovation. Let's just give them some energy this morning. All right, get on out your seat, get them a standing ovation. And for those of you that feel that you went an extra mile, have a seat, and the rest of us give them a standing ovation. All right. Nobody? Okay, I thought I'd try. Okay, he need a standing ovation. Let's give him a standing ovation. All right. All right. As you heard the panel here, and it's very important that we come to forums like this because networking is very important. How many of you all believe networking is very important? All right, so this is about networking. You know, all of us got our independent lives from agencies, different backgrounds, and so it's important that we come to forums like this so we can enhance what we're doing by partnering. So at this time, we're going to turn it back over to the panel, and they're going to each give a presentation, 10 to maybe 15 minutes on what they actually do. And then after we go through the panel, we're going to open it up for you to ask questions. Is that okay? All right, Yabo? All right, okay, let's start off right here.
Thank you, sir. So as many of you know, I'm sure that there was no way to avoid this in the media last year. A court decision came down in December of 2012 in Illinois. And if you look back a few years ago, there's been an absolute sea change in policy, particularly in the city of Chicago, with regard to how our gun laws are enforced. In 2010, the city of Chicago was the last major jurisdiction in the country that had an outright ban on handguns. It was a municipal violation to bring a handgun within Chicago city limits. a court case came down in 2010 from the U.S. Supreme Court saying that an individual has a fundamental right to keep a handgun, a firearm in their home for purposes of self-defense. So that municipal ordinance was struck down. What the court didn't decide at that time was whether an individual also has a right to carry a firearm outside of their home. And what happened in 2012 is the court issued an opinion giving a mandate to the Illinois General Assembly, the state General Assembly, so coming from the federal courts down to our state legislature. The mandate, in so many words, said that an individual has some form of a constitutional right to carry a gun in public, a handgun in public, and ordered the Illinois General Assembly to come up with some sort of what we call a concealed carry law, come up with some form of a way for a person to get a permit that would allow them to carry a gun in public. There was, countless weeks and months of debate. It was a very unprecedented decision and an unprecedented way of sort of pushing the legislature's hand to come up with a licensing regime that would allow for concealed carry. And of course, there's a lot of apprehension now as to how that law is going to roll out, what the impact is going to be. The law passed in the summer of last year. It came down on the last day of the mandate. In typical form, our legislature waited until the absolute last minute to get this law passed. But it was after months of careful negotiation. A lot of the issue was polarizing on both sides. So I'd like to give you a little bit of background on the law. I know I could probably talk for hours about this law and the nuances. Anything that I miss, though, due to our time constraints, there's a fantastic organization called the Illinois Council Against Handgun Violence, and they have put together a pamphlet of frequently asked questions and sort of the ins and outs, the nuances of the law. These booklets are available at the front table as you walk out. So for anything that I miss that I don't have an opportunity to follow up with you on, refer to this booklet and refer to this organization for any of your questions. So with the caveat that we were forced to come to an agreement and decide how to implement some sort of policy to issue concealed carry licenses, I always sort of start this presentation out knowing that there has been a sea change in policy over the past couple of years, and knowing that there is a lot of apprehension about how this law is going to play out. Right now, the Illinois population is about 12.8 million, and of that population, there's 1.7 million FOID card holders. That's the Firearm Owner's Identification Card. And what that allows you to do is it allows you to purchase and possess a firearm. And that requirement has been in existence for about 35 years. In order to get a concealed carry license, you're going to have to get an FOID card. And there's about 1.7 million FOID card holders right now. The Illinois State Police estimate that of those 1.7 million FOID card holders, about 300,000, maybe on the high end, 500,000 people will, at some point within the next couple of years, obtain a concealed carry license. And 500,000 people does sound like a lot, but when you look at it relative to the entire population, you're looking at about 3 to 5% of Illinois' entire population is going to have a concealed carry license. And then of those licensees, if you break that number down even further, how many people are actually going to be able to lawfully carry a firearm throughout their day-to-day lives based on the number of prohibited areas that I'll walk through in a minute. The number of people that are actually going to be able to lawfully carry a concealed firearm in Illinois is actually a very small one. So I usually preface this, before I get into the nuances of the law, usually preface this with the impact of the concealed carry law. It is a sea change in policy, but there's not going to be, 1 out of every 2 people in the city of Chicago are not going to be carrying a concealed firearm as a result of this law. So applications rolled out January 5th was the first day that the Illinois State Police made applications available on their website to carry a concealed firearm. Those licenses were actually issued about a month ago. They started to actually issue the licenses, so people already are receiving their concealed carry license and are able to lawfully carry, just so everyone knows. The requirements to obtain a concealed carry license, a person has to be 21 years old. They'll have to pass a criminal background check similar to the same criminal background check that's required under the FOID card. And there's also a mental health component to that. The Department of Human Services, there will be a mental health screening for anyone trying to obtain a concealed carry license. Again, just in the same manner that there is for a FOID card. The person will also have to complete 16 hours of training. That's the highest statewide training requirement in the nation. So it'll be probably a 2-day course, a weekend course, and a licensee will have to pay a $150 fee in order to obtain a concealed carry license. Illinois came down with what's referred to as a shall issue state, meaning that if an applicant meets all of the statutory criteria to obtain a concealed carry license, the state police are required to issue them a concealed carry license. However, we do have an additional screening process for local law enforcement to screen the database of applicants. And for example, if a person doesn't have a conviction that would disqualify them for a concealed carry license, the City of Chicago Police Department, for example, will be able to screen the applicants and see maybe if they have a substantial amount of arrests in their record, maybe they're not the type of person that we want to obtain a concealed carry license. The City of Chicago Police Department would then have the ability to issue an objection that would go to a review board and see whether that person is fit, is a threat to the public safety and is fit or unfit to own a concealed carry license. So once you go through the screening process, you take your class and you pay your fee and you make it through the objection period. What does a concealed carry license give you the opportunity to do? It allows you to conceal a single handgun. You have to keep the gun concealed at all times that you're carrying it, and you can also keep the firearm loaded in your vehicle. So for all intents and purposes, the vehicle now serves as what we refer to in the law as a safe harbor. So an individual can then carry in public in certain areas that are not restricted areas. They would have to keep the gun concealed on their person at all times. And if they're driving in their vehicle, they could keep the gun stowed, loaded in their vehicle out of plain sight, and the vehicle would, of course, have to be locked. So instead of reading through the list of prohibited areas, I'll hit on some of the high points and again refer to the Illinois Council Against Handgun Violence's detailed explanation for those prohibited areas. But generally you have basically anywhere where there's a large number of people, there are statutory prohibitions for individuals to carry a concealed firearm in those places. So you have schools, parks, forest preserve districts, any government building, libraries, bars are a prohibited area. And then your large facilities, whether they're public or private facilities, hospitals, stadiums, airports, amusement parks, public transportation property. That was a more novel provision in our approach. Public CTA property, METRA is all going to be considered a restricted, statutorily prohibited area, and we put that in there at the request of the CTA and of the Regional Transportation Authority that did not want people to feel that they were authorized to not only carry a loaded gun on a red line train, for example, but to then use that gun in self-defense and open fire on a crowded red line train. We thought that would have been a bad policy. College and university property, and anywhere where there's a public gathering or special event that requires a permit. Those are just some of the high points, but the list does go on, and again, I would refer you to the Council Against Handgun Violence. Private property owners will have the ability to elect to prohibit concealed carry. So a private business, strip mall, for example, they will have the ability to either allow for concealed carry, essentially do nothing, and an individual will be allowed to bring a concealed firearm into their business while they're shopping or for whatever purpose they enter onto the property. If a business elects to prohibit concealed carry, what they have to do is and this is actually contained in the Council Against Handgun Violence's pamphlet, what they would have to do is they would have to take this sign, kind of like a no smoking sign except for no guns, and post it at the front of the entryway to their property. And what that does is that puts people on notice that they are prohibited from carrying into the property. If you do carry into a prohibited area, it's going to be a misdemeanor crime. And if a licensee gets repeat offenses, more than one offense, not only will they get a misdemeanor charge against them, but they would also have their license suspended on a second offense and then revoked on a third offense. There's also a penalty against carrying while intoxicated. So just like there's a DUI for driving your car while intoxicated, there's going to be a penalty tied to the vehicle code. If you fail a field sobriety test while you're carrying a loaded gun, or if your blood alcohol level is over 0.08, just like with the vehicle, there's a carrying while intoxicated penalty now. I think I'll hand it over to Monica at this point. Again, feel free to follow up with me with any questions that you have, or refer to the Council Against Handgun Violence booklet for any questions. Thank you.
Good morning. Excuse me as I look at my phone. I'm one of those people who carries my iPad and my phone everywhere and has all my notes on it. I don't like to carry paper, so I'm not texting. I am just making sure I'm on point and on topic. I'm going to talk about medical marijuana or medical cannabis. And this year, as of January 1st, Illinois has joined some of the other states in implementing a program that will allow individuals to apply for a medical marijuana card, or a medical cannabis card is the more accurate term. This card will allow individuals with about 30 to 35 different conditions to use cannabis in a medical form and in a medical, in certain areas, I'll say it that way. And also, if you need resources, one good resource to look at is the Marijuana Policy Project. That's mpp.org. It has a lot of data, not just about Illinois and all the programs and the regulations that exist currently in Illinois, but it follows and tracks the policies and laws throughout the nation. So currently, this program is set up as a pilot program, meaning that we have 4 years in which they will track data and see how this program works. It's going to sunset basically on January of 2015. At that point, it'll either become a full-fledged law, they might tweak it, or the sunset provision is reached and the program's over. If you qualify for one of these 30 to 35 conditions, you can go to your physician who will recommend that you be a part of this program. You also be given a card. There'll be a background check if you have a criminal history, especially one pertaining to drug convictions. You will be prohibited from applying for the card, unfortunately. But if your doctor recommends that you can qualify for the card, you'll then be able to use the card to go to what we call dispensaries. There'll be about 60 dispensaries throughout the state. Currently, they're in the process of setting up the rules and regulations for these dispensaries, and it works similar to that of a pharmacy program. You will be issued about 2.5 grams per 2 weeks is how much you're allowed to get. I don't know what that translates into as far as actual, depends on if you're using it as rolled joints or if you're using the oils, etc. But you will have it for 2.5 grams for a 2-week period. You may be wondering, how do the dispensaries receive their marijuana? It's also regulated. It's going to come from a dispensary. There will be 22 dispensaries throughout the state. They're all assigned, and the cannabis will be tracked throughout this whole process from where it's grown and cultivated all the way to where you are as a user. If you have a condition that makes you either immobile or perhaps you're elderly, or maybe you just want to assign a caregiver, you can designate someone in your family, a friend, a medical professional. You get to choose who will be a caregiver, and that person just has to be 21 years and older. There'll be a background check done on them, and they are able to go receive your prescription from, not the dispensary, from the dispensaries, and bring it to you. You will still be held to a number of the laws that currently exist. You won't be able to use your prescription on a public place. That's not something you can do. You can use it in private property. However, if you are a tenant, a landlord can designate the area as a cannabis-free zone, and you will not be able to use in that apartment. So it's something you want to look at. If you live in federal housing, you will not be able to use the prescription. Keep in mind that on the federal level, cannabis is still considered a Schedule I drug, which means it basically has a highly addictive property with no actual medicinal use, despite what the science has said. On the federal level, the president issued not necessarily a mandate, but an order a few years back that said that they were not going to focus on prosecuting individuals if they are adhering to the state laws. So if you're using it as a medicinal purpose, you're not trafficking it, you're not using it around schools, et cetera, and you're adhering to the law, you should not face penalty, and so long as you are actually working within the confines of the law, it's not something that you have to really worry about. The third thing is, if you work in certain professions, we're considered law enforcement, even though we are not officers. We could not apply for this program. Firemen, they will not be able to apply for this program. You cannot have both a cannabis card and a concealed carry card. That is another prohibition that people are unaware of. But it's an important prohibition. And lastly, they have, we're working right now in the legislature to define how they're going to define intoxication and DUI laws. Currently, any trace amount counts as a DUI. However, with the card is not a defense nor a bar to arrest. However, if you are not impaired, they'll treat it like alcohol, it seems right now, but they're looking to modify the laws on that to see exactly what they're going to do ultimately, and looking to other states for guidance. Those are kind of like the highlights of the program. I'll wait for questions at the end, and feel free to ask, but I'm going to pass it on to Mark, who's also in our division.
Thank you. So again, my name is Mark Kammer. I'm the supervisor of alternative prosecution and sentencing for the state's attorney's office. I always like to point out that even though I work for the state's attorney, not only am I not a prosecutor, I'm not even an attorney. My background is I'm a licensed clinical professional counselor in the state of Illinois and worked as a psychotherapist for my entire career until coming to this office in 2000. I point that out only because I think it's important for people to realize the perspective that some people in the law enforcement community are taking as far as nonviolent offenders who are perceived as not being a significant risk to public safety. So and in the course of my time with the office, I think one of the things that we've tried to do is to develop a whole series of interventions, legal interventions for individuals that are outside of the stereotypical traditional interventions that people think of when they think of the state's attorney or law enforcement. My unit is responsible for two primary areas, one being alternative sentencing, which is typically treatment courts and specialized probation programs. Treatment courts are drug treatment court, mental health treatment court, and veterans treatment courts primarily. There are about 20 of those in Cook County. That we try to have as many of them as possible located as close to people's homes, so people are geographically close to where they might be involved. The purpose of the treatment courts is to look at individuals who have extensive criminal backgrounds and extensive issues, problems that have contributed to their criminal activity. And instead of traditional prosecution of those individuals, look at treatment as the primary way of intervening with them. So instead of an individual who, say, has been to the Illinois Department of Corrections 5 or 6 times for similar types of offenses, now we're going to try to do treatment with them in the community as opposed to sentencing to the Department of Corrections. Again, those are individuals with fairly extensive backgrounds. Those programs involve people pleading guilty and being sentenced, convicted and sentenced to somewhere between 18 and 24 months of a specialized probation program. Okay. The other side of what we do, our unit, is alternative prosecution, which is a very different process. It's typically for people who have much less criminal background, usually people who have not had felony convictions in their past, who've not been arrested extensively, who have not been sentenced to the Department of Corrections. What makes those programs unique is that they do not involve a conviction. Where the treatment courts are wonderful options for people, they do involve a conviction. The alternative prosecution programs do not involve a conviction. And there are 3 of those major programs at this point. The first is what's typically called drug school, which is a diversion program for individuals charged with low-level possessions of controlled substances or illegal substances. And that involves 10 hours of education. It's not treatment. We make it clear that it's not treatment. If somebody needs treatment, they are referred elsewhere. But it's education about the different negative consequences associated with substance use. And if people complete the 10 hours of education in that program, their case is dismissed outright. They don't even have to come back to court. Their case is dismissed and they're done with us, or we're done with them. People are allowed to do that program every 3 years. If being in the program the first time helped keep them out of interactions with the criminal justice system for at least 3 years, they can then be offered it again if a situation arises. In my time in the office since 2000, there have been over 40,000 cases that have been dismissed by the State's Attorney's Office through their people's participation in this particular drug school diversion program. That's over 40,000, and primarily for felony cases. So about 3 years ago, the State's Attorney came to us and said that basically that we have this diversion program for people who are charged with drug offenses. What about people who are charged with other types of felony offenses? Why should they not have the opportunity to do something similar and avoid prosecution? So we developed the Felony Deferred Prosecution Program, which is locally referred to as Branch 9. That program involves people who are charged with felony offenses, not drug offenses, but felony offenses such as retail theft, burglary, criminal trespass, falsifying IDs, credit card fraud, stuff on that order. Again, nonviolent offenses. But if they meet the criteria, which is basically no past felony convictions, then we are able to offer them this type of diversion program. Another thing that's unique, 2 things that are unique about the felony program. One is that if there's a victim involved, the victim must agree to this. Our office contacts the victim and says, your car was burglarized. We have this individual who did that, who we believe did that, and we're going to offer him or her an alternative, which is this program. If the victim says no, then prosecution proceeds as traditionally. If the victim says okay, which we have found to be the vast majority of cases, then we offer it to the program. If they agree, then they are not sentenced. They are just assigned to the program, which runs for 9 to 12 months. And basically, people have to adhere to the program, stay out of trouble, and pursue educational, vocational, and treatment options as are identified by the people and the staff who are working in the program. If all that works out, their charges are dismissed at the end of their 9 to 12 months with us. And again, they can apply to have the original arrest expunged immediately. There's no waiting period because it's not a conviction. It's just a dismissal. The third program, and all of this from my background in healthcare, we keep moving further and further towards the beginning of the process. It's like in healthcare, if somebody has an ingrown toenail, you treat the ingrown toenail. You don't amputate their leg. So we're trying to find the least intensive, least intrusive ways of intervening with people as possible. So it was logical that since the felony program was working so effectively, that the next step would be to intervene with misdemeanors. And what makes the misdemeanor program unique is that it doesn't involve long-term supervision at all. It involves people being linked to community services. So if somebody who is assessed or screened as having potential mental health issues, we will set up for them to be screened by a mental health provider, licensed provider. They'll do one appointment with that person and then go back for a second appointment and hear what the recommendations are, and then we're done with them. They don't have to follow any of them. They don't have to do anything. They just have to go to these 2 appointments, and then we're done. If they're a veteran, they have to make an appointment. We will make an appointment for them to go to the VA hospital, get connected to them, and also go to the John Marshall Free Veterans Legal Assistance Clinic. If they do those 2 things, again, we're done with them and their charges are dismissed. So basically, we're talking about, in any given month, roughly 2,500 cases that are being addressed by my unit in terms of some type of alternative prosecution or sentencing. Again, the goal is to get people education, linkage to services, and/or treatment instead of what people typically think of in terms of prosecution. And the last thing I'll say is that I tell people all the time, if you guys go out and do these programs and you do them sloppily, haphazardly, they're going to be successful. If you do them well, which I think we do well, they're wildly successful. People with extensive backgrounds have 90% decreases in criminal activity. People who are in the felony deferred prosecution program, over 90%, I think it's 98% of them have not had a felony arrest in their full year after their case is dismissed. And in the misdemeanor program, within the first 3 months after completing that program and having their charges dismissed, well in excess of 90% of those individuals have no connection with the criminal justice system at all. So we're trying to get people out of the system or keep them from getting into the system as much as possible. Okay, and I'll be around. I'd be happy to talk about any of these things later. Thank you.
Thank you. I want to apologize ahead of time. I have to leave at 11:15, and Karen has been gracious enough to allow me to speak before her. So if you see me walk off the stage, it's not because I don't want to be here. It's because I need to be someplace else. So again, I apologize ahead of time. And I'll do a little bit of house cleaning. My name is Larry Merritt. I'm with the Independent Police Review Authority. Our website is iprachicago.org. There's a wealth of information on the website. Again, iprachicago.org. Our general number, if you have a question for me that I may not be able to stick around and answer, excuse me, is 312-746-3609. Again, 312-746-3609. If you have any question or need any assistance, don't hesitate to call me. Again, my name is Larry Merritt. That's M-E-R-R-I-T-T. All right, so who are we? Independent Police Review Authority, or IPRA. Well, if you go back to the history of our function, we're formerly known as the Office of OPS, which was housed within the Chicago Police Department. Over time, as you can imagine, people kind of grew leery of going to the police to complain about the police. There was a lack of confidence in the system as it was constituted back then. A number of high-profile cases, the Anthony Abadi case being one of them. It was in the news internationally. Big burly off-duty police officer beating a bartender, a small woman, probably 110 pounds, if that. In September of 2007, IPRA was created by ordinance, and so we have certain cases that are under our jurisdiction that we will investigate. We do, however, intake all complaints of allegations of police misconduct. There's no screening process, so you can, file the complaint in, a number of ways. You can come to our office and do it in person. Our office is at 1615 West Chicago Avenue. You can go on the website. You can file the complaint. You can also do it via email, and you can also call us, and the complaint line is 312-746-3594. Again, 312-746-3594 is the complaint line. So what are our responsibilities? Like I said, we intake all allegations of misconduct. We investigate those allegations that are within our jurisdiction. and we will refer those that are not in our jurisdiction to the Internal Affairs Division. So when I say our jurisdiction, we cover allegations of excessive force, domestic violence involving a police officer, whether it's their, wife, girlfriend, boyfriend, husband, child, or whatnot, verbal abuse with bias. So if the police officer, calls you, an MF or curses you, that's not our investigation. But if they use anything derogatory in terms of your race, your sexual orientation, your religious affiliation, and whatnot, we would investigate those allegations of verbal abuse with bias. Coercion, threat of violence from an officer. We investigate all officer-involved shootings as well, taser discharges, amongst other categories. But those are the main categories that we investigate. We also take a look at extraordinary occurrences, shortly known as EOs. So if you go on our website, you will see we do quarterly reports, we do yearly reports, and an EO, an extraordinary occurrence, is a death or serious injury in custody. So from the time a person is arrested and taken to lockup, before that person is transferred to the county, any serious injury or death in custody of CPD, we will investigate that case as well. So on a yearly basis, we intake about 9,000 cases. We retain about 3,000 of those cases. Our office, at full capacity, we have about 54 investigators. We have access to CPD information, so reports, radio and computer records, GPS records. So if you say the incident happened on Jackson and Racine at this time, our investigators can pull up attendance records. They can look at the GPS records to see that there was a police car that was traveling through the vicinity of Racine and Jackson at the time or thereabout that you said it happened. We use the Illinois State Police Crime Lab for forensic evidence. The blue light, the pod cameras, we get access to all of those and any other physical evidence. And we go out on, canvases in the community, and we try to obtain as much cooperation from witnesses that we possibly can. What we are required to have by law is a signed affidavit. So what is an affidavit? Basically, it is you putting your name to paper that the alleged, that the alleged misconduct took place. So if you are willing to come and file the complaint, it would be right, and by law we have to have it, that you would be willing to sign your name and say, this happened, and my name is so-and-so, and give us your signature. If we do not, through subsequent outreach, whether it's a phone call to you, an email to you, we come to your house and knock on your door, we send you a letter. If you're not going to cooperate and sign the affidavit, the case is closed. So the outcomes of the investigations are sustained. So that means the allegation was supported by sufficient evidence to justify disciplinary action. So we were able to prove with the preponderance of the evidence that something happened. Not sustained. The allegation is not supported by sufficient evidence which could be used to prove or disprove the allegation. So a classic he said, she said situation. Officer, an offender, dark alley, the officer did A, B, and C to me. Well, there's no cameras, there's no witnesses, there's no DNA. It's a classic he said, she said. So we couldn't prove it and we couldn't disprove it. So it would be not sustained. Unfounded, the complaint was not based on facts as shown by the investigation, or the reported incident did not occur. So you said, well, the officer smacked me or punched me or kicked me at this location at this time. Well, we have video from the bank, and it shows the officer walking up to you and shaking your hand and walking about his business. Well, it did not happen. You said it happened, and we were able to prove that it did not happen. So it would be unfounded. And the last category would be exonerated. So you said, well, the police officer punched me. Okay, well, what happened prior to that? Well, I punched the police officer. Okay, well, the officer would be within his rights to use that appropriate force. So if the force or the allegation did occur, but it was within the officer's use of force model, then it would be exonerated. So we try to be as transparent as possible. Again, if you go to our website, and that's iprachicago.org, we put the officer-involved shootings report up quarterly and yearly. We have quarterly reports, yearly reports, taser discharge reports. All abstracts of sustained cases are put up there as well. So it gives a summary overview or abstract of what happened. On this day, the officer responded to a call of this nature, and such happened. So all of that information is on the website. But what's redacted is the officer's name and the complainant's name. So no identifying information is put on the website, but the incident and what happened and what the officer received as punishment, that information is put on the website. So again, if you have any questions, please feel free to call me. I know this is kind of the Cliff Notes version of IPRA, and by no means can I give you all of the information of what we do and how we do it in a short period of time of this, but please feel free to call me again at 312-746-3609, and I'll take your call. Just ask for me. Or you can start by going to our website again, which is iprachicago.org, and there is a wealth of information on the site that may answer some of your questions prior to you giving me a call. Thank you.
Thanks, Larry. My name's Karen Sheely. I'm from the American Civil Liberties Union, and I'd like to tell you a story. In March 2001, a young black man was walking down Howard Street. He was 20 years old, and he was going to meet some friends. A police officer stopped him and ordered him against a wall of one of the businesses along Howard and asked him to put his hands up against that wall. The young man agreed, and then the officer patted him down. He patted down his arms and his legs, his back and his stomach, and then he used a flashlight to look down his pants, both in the front and the back. That young man, his name was Shawnee Davis, and he was an Olympic athlete who represented the United States in the Winter Games as a speed skater. After that, he's commented many times that he was respected and treated well wherever he went all over the world, but he didn't get any respect in his own hometown. After that, he was afraid to go near the Howard Red Line to visit friends, and it changed his perspective on the city and on the police. I'm telling you that story because shortly after, the American Civil Liberties Union brought a lawsuit on his behalf. We sued because before a police officer can stop someone, they need to have reasonable suspicion that the person committed a crime. And before they do a frisk, a pat down, or another way of assessing whether or not somebody has a weapon, they need to have reasonable suspicion that that person has a weapon. Coming out of that suit, the police department had to start collecting more information about the stops and frisks that they conducted on the street. Our concern is, looking at that going forward, in the last about 13 years, is that we're continuing to see issues where police officers aren't able to justify the stops that they're doing. And they're not justifying the frisks in most of the situations when we're reading the contact cards. This has been a major issue in other cities across the country. You might have heard about the lawsuit that happened in New York. In New York, they collected better data than we collect in Chicago. And they found that it was only, with the stop and frisk, it was only about 12% of the time that reasonable suspicion that the police officer had actually led to a ticket or an arrest. So, we can see that there's likely a problem. We think that there's also a problem because of the high rate of arrests for marijuana in the African American community. If you're a young black man, you're roughly 12 times more likely than a white person to be arrested for marijuana. And we think that that is very likely because you're more likely to have a police officer's hands patting you down. we're concerned about this, and I started with a story because I can tell you the statistics. I can tell you that, about a quarter of the times the contact cards are filled out, it doesn't seem like there's enough information to show that there's reasonable suspicion. I can tell you the 12 times more likely to be arrested. I can tell you that data, but stories are what move people. And the reason I'm here today is that we want to do outreach to gather stories from you, from your children, from your cousins, from your brothers, because we think that the stories are a more powerful way to explain the impact of how this stop and frisk police practice has on people and on entire communities. So if you go out front, I've left some flyers with the ways that you can contact the ACLU if you have one of these stories and you'd like to share it. You can contact us online on aclu-il.org/intake. You can call the line that we have set up just for these stories. The telephone number is 312-201-9740, extension 301. Or you can, we don't have our address on here, but it's 180 North Michigan Avenue, Suite 2300, and you can write us a letter or drop a note card in, and we would love to get back to you. Again, my name is Karen Sheely. The organization is the American Civil Liberties Union of Illinois, and I would be happy to talk to anyone about this later, and we're looking to come out into the community and talk as often as possible as we can about this. So if you're part of a different organization, or if you know that there's a meeting coming up at your church or a different community center, we would love to come out and join in and have you be part of this conversation. Thank you.